Hi there. Thank you so much for joining us for today's webinar. We're just going to give everyone a couple minutes to join before we start. It's 11:59, so I will make this announcement again at noon as people are joining, but we'll start this in just a couple minutes. Thank you. For those of you that are just joining, we're just waiting a couple more minutes as people are joining the webinar. We'll be starting in just a couple minutes. Thank you so much. Hi, everyone. We're just going to give it one more minute as people are joining the call. We'll start the webinar in just a minute. Thank you. All right, everyone, we're going to get started. My name is Rogine. I'm an associate attorney here at MPLG. I have here with me our senior paralegal, Shayna, and this is our quarterly webinar, and the subject of today's webinar is the H-1B CAP lottery for fiscal year 2019, and we'll be going over some filing tips and best practices, sort of going over not only our process here in the office, which most of you are familiar with, but also sort of some changes that have taken place under the new administration, some trends that we see, and some recommendations that we have to ensure the strongest petitions going out. Okay, so I assume that all of you have received our H-1B initiation email last month. I just wanted to touch on some timelines. So in that, you'll see if you are on the actual webinar portal that we have uploaded some handouts. These were all emailed to you at the time of the initiation email. You will see our Excel worksheets, one's for product companies, the other one's for consulting. In there, we have basically the information we need for companies that have multiple people applying for CAP this year. So it's their names, their job title, their job location, their SOC code. You'll see for each type of company, there's specific information that we're requesting. I also have our initiation worksheet in there, also our client expectations overview, as well as our company document checklist. So we'll be going over that shortly. So as you have your candidates ready, we ask that you forward along that initiation worksheet as soon as possible. For the corporate details, in the next week or two, we'll be reaching out for what we're calling a corporate document refresh. So if you filed last year and you might have filed the 2015 tax returns, you might need your 2016 tax returns, you may have updated your lease, things like that. So we'll be reaching out to you. And then finally, this is very important. Unlike our regular filings during the year, we do require that the DHS checks, so all the filing fee checks, are sent to our office by the company and signed and received by March 16, 2018. We will not be issuing checks for any CAP cases from our office. So deadline. So for the early bird special, we ask that we receive the completed initiation worksheet by February 16, 2018. So that's next Friday. So end of day next Friday, if you've sent over a completed initiation worksheet, we'll touch on that in just a minute, we'll be able to provide our early bird discount. We'll be charging the regular fee thereafter through March 9th, 2018. So we do need that completed initiation worksheet for us to initiate each case. And then any initiation worksheet received after March 9th, there is an additional fee. And we'll get into the reason why, we have sort of this timetable. And then finally, we'll talk about LCAs, but the LCA requires at minimum 7 business days. I know that a lot of you have experienced that we get the LCAs in 7 calendar days during the regular course of the year, but because it's so high volume for the Department of Labor, 7 business days is actually the standard. And so because of that, we do require all that information in the initiation worksheet so we can get these cases initiated. So the initiation worksheet, most of you have seen this. It's a little bit different than our usual one, but it must be completed to initiate the case. We do require that we initiate the Benny doc collection, so the documentation that the beneficiary provides. We ask that we collect that directly, which is why we ask for the employee email. We do need the job title and the SOC category that you would like to place a person in. And so for every case that comes in, we do a case-by-case analysis to make sure that the job title, the SOC, and the detailed job description align, and that's extremely important, and we'll get into that, as well as the proposed salary. For the location of the employment, we'll need that, and there might be 2 work sites or 3, so we'll need that as well as the itinerary, and then your current number of employees and H-1B employees. So the labor condition application, this is where we kick off how we initiate the case. So once we have an initiation worksheet, once we've reviewed it and we confirm that the salary, the job title, the SOC code, everything aligns, we prepare this labor condition application for the company review. You must review each LCA and confirm via email that the LCA has been posted in 2 conspicuous places. There are posting requirements for LCAs. All of that information is actually in our LCA for posting email. If you have any questions about that, please don't hesitate to shoot me an email or give me a call after this and we can discuss that. What you're looking for in the LCA is you want to make sure the job title looks right, the SOC code looks right. You'll see that the begin date will be 6 months out from when we actually file. So for CAP cases, as most of you know, the start date is usually October 1st, but we can't get the LCAs today, for example, to October 1st because that's more than 6 months out from today. So the earliest or the latest we can request the start date is 6 months out from the day that we prepare the LCA. And so from there, we can determine per case how much time that we're requesting for the end date. You also want to make sure that the salary matches and that the work site location or locations is correct as well. And so once you've reviewed all that and once those LCAs have been posted in 2 conspicuous places, you send us an email confirming that and let us know, and then we're able to file it with the Department of Labor. So this is a DOL wage level. So in the past, we would, get your initiation worksheets, we'd see the wage, we'd sort of just place the wage level or select the wage level based on what came to us, and for the most part, everything was fine. In the last year, the approach has completely changed. This is a trend that is across industry, across occupation category. Basically, the USCIS is doing what's been on the books forever, but they're now enforcing it. And what they're doing is they're looking at the wage level that is indicated in the labor condition application in evaluating the job that is being offered in the H-1B petition. So what does that mean? So in the past, you would file at a level 1, and that was it. There was no question about the job duties. It should have been fine. But actually, the level 1 wage level is really for a person who's at an entry-level position. And so I have the descriptions here. I can forward this along after the webinar if anyone would like a closer look. I have the link down there about that includes where you can find this guidance. But actually, the level 1 entry wage is for beginning level employees. It's really for someone who is straight out of school, has no real experience, and the job really is to become familiar with the methods and practices of the employer. They don't really do very much high-level work. They work under close supervision. And so, as you can see, the Department of Labor actually identifies certain titles, so research fellow, a worker in training, internship. Those are indicators of a level 1 wage. And so what we saw in the last 6 months is an overwhelming number of RFEs on this issue, not just at our office, but across the country. The American Immigration Lawyers Association, which is our immigration bar that we're members of, they started calling for examples, sort of seeing what these challenges are. And so in considering how you are placing the wages, we will be pushing back if a wage level is at a level 1 wage and ask you, is this actually an entry-level wage? I will tell you that it is now a red flag if you're filing at a level 1 wage for most occupations. If not all, it will trigger an RFE. It does not necessarily mean you can't overcome it if it's actually an entry-level wage. So please feel free to speak with me with any considerations that you have there. There are exceptions. So if it's, for example, a manager role, so computer and information systems manager position, then at that time, that might make sense because that's a natural progression of a role. So level 2 is sort of what we recommend as a starting place. It's, as you can see, it's for employees who have attained through education or experience a good understanding of the occupation. So we can discuss for the levels what to do for each case as the initiation sheets come through. So your standard occupation classification categories. So we are also seeing a trend in what we're calling disfavored categories and then problem categories. So for every position, there is some form of an SOC code that we have to place these jobs in. And what the USCIS uses in determining whether a position is a specialty occupation is what's called the Occupational Outlook Handbook that is issued by the Department of Labor. And so how does that relate to these SOC codes? Not all SOC codes, but some SOC codes have these what are called OOH overviews. And so when they have them, if you go to bls.gov, you can see for example, software developer, there is a page and it says how to become a software developer. It identifies that, you know, a software developer usually has a bachelor's degree in computer science, or it's common. For other positions, it might say it's just a high school diploma, which is common. And so when there isn't an OOH page there, the secondary authority, it's called ONET. And that's a secondary source of sort of defining certain positions. And so that's become a cause of of RFEs in the last year. So I'm going to break it down by the different occupation categories and go from there. So for disfavored categories, there's computer programmer. I think most of you have heard about this in the last year with our warnings and our emails. There was a memo that came out on the first day of filing, March 31st last year, that basically deemed computer programmers at a level 1 not a specialty occupation. Computer programmer as a whole has been fully challenged, and we do not recommend filing in this position unless it really is in fact a computer programmer position, and at that point we are comfortable maybe filing at a level 3, and that's in our MPLG expectations overview, but computer programmer level 1 will very likely be denied. Now, obviously there's case-by-case analysis, but if we do not recommend usually filing in computer programmer, there are alternative categories you can consider, which includes computer systems analyst and software developer, and we can talk about that on a case-by-case basis. The second category this has been for a very long time, it's the market research analyst position. And what's happening there is you might go on the OOH page on the Department of Labor on BLS.gov and see that it says that a bachelor's degree is common. However, the USCIS has not treated market research analyst positions as specialty occupations for a very long time. And so there are other categories that we can discuss to do instead. And so if you are considering these categories, please reach out to us. We're happy to discuss them with you, but these are fairly disfavored categories. And there's just a risk of denial, frankly, if you're filing in these categories. Now, the next one's the problem categories. So we'll start with the one where we're still comfortable filing in, which is computer systems analysts. We're seeing it feels like a coin toss, computer systems analysts, regardless of what level you're filing, whether it's level 2 or level 4, they're issuing an RFE on it, but we're getting them approved. So so long as it's a strong case, we feel comfortable moving forward with computer systems analysts, but minimum at a level 2. As I mentioned, level 1 generally is disfavored unless it's in fact an entry-level position that can be defended as one, and we would like to we will definitely be talking with you if we see level 1 requests. But we don't disfavor computer systems analysts. We think that we can overcome those. We have had success in that category. We just warn that there is a likelihood of an RFE being issued for specialty occupation if you file in the computer systems analyst category. The other two that have become problem categories are database administrator. That has been a trigger for RFEs and some denials, and so there are other considerations for alternative categories for database administrator. If they are in fact a database administrator, we'll work with you. We would rather file at a higher wage level, maybe even level 3. Obviously, it's a case-by-case analysis. And something that we actually, our firm participated in a business immigration attorney roundtable a couple of days ago, and what we're starting to see, not just at our office, but across the board, is the issuance of RFEs and even some denials in the computer occupations all other category. And so what falls under that category? That could include your database architects, that could include your QA analysts, your business intelligence analysts, your project managers. We were talking about how OOH has certain pages for certain occupations. These are occupations that don't have OOH pages. They have ONET subcategories. So you see it's 15-1199, it might be 15-1199.01. But because it's not, the OOH does not recognize, for example, a business intelligence analyst as a separate occupation, the USCIS seems to get confused on what to do with this category as of late. And so they have been issuing RFEs on them, and there have been denials on otherwise strong cases. So if there are alternatives that we can recommend, which include software developer. These are for those technical roles, and other occupation categories that we can discuss on a case-by-case basis. But we bring these to your attention because these are categories that did not used to have as many issues in the past, but we do want to bring these to your attention as we are under a different administration in a different climate. Public access files. So you may have heard me talk in the last webinar about this. If you joined us, you get emails from Shana about public access files when you initiate your first case with us. But this is extremely important, regardless of whether it's CAP or non-CAP. Why a public access file? You must, by regulation, create a single file evidencing compliance with the H-1B laws that is readily available to the public or Department of Labor. And so the first step in creating a public access file starts with that LCA that we send you. So you should have templates on how to create your public access file attestation documents. If you don't, please reach out to me. I'm happy to discuss that with you. The first one is your posting notice for your LCA. So once you create it, you have to record how long you're posting your LCA. So you have a requirement to post for 10 days, and you have to actually record the first day that you've posted it and when you've taken it down. So that's just one example. So the different things that go in it include a copy of the signed certified LCA, the rate of pay for the H-1B worker, your actual wage memorandum, your prevailing wage determination, proof of LCA posting, and benefit summary. There are templates that have been provided to you once you joined our firm. If you have any questions about any of that, we're happy to discuss it with you, but this is a very important piece in H-1B compliance. And in terms of how long you're supposed to keep them, you're supposed to keep them updated as long as the person is employed. And if the person leaves and is no longer employed, you have a requirement of keeping that public access file for 1 year beyond the employment. All right, document collection. So what our firm policy is with the beneficiary is that we collect the documents from the beneficiary directly. So what you'll see for those of you who have already initiated some CAP cases with us is that Shana has initiated the document collection, and so that's why we ask for the beneficiary emails. We really appreciate you working with us in doing that. What happens is it's more efficient. There are questions that might be raised during the case that the beneficiary might more readily be able to provide us documentation of. So for corporate documents, we do have quite a bit of documentation collected for our clients. Some of you we regularly file for, some of you we might only file during CAP, so we do a corporate document refresh. Examples of what we'll be asking for in the next coming weeks include your more recent tax returns. If you have requested a tax return extension for 2017, we'll need a copy of that. We are looking at all documents being correctly executed. So something we're seeing as a trend across the board is the USCIS is reading through every document. So you might have submitted a 30-page lease agreement and it's been okay for the last couple of years. We're seeing RFEs where the lease might have said that it might have expired in 2016, you might be going month to month, but we need evidence that the lease is still ongoing, or there's a signature missing. They're calling those things out in RFEs. So we'll be looking at these documents and asking for updated, correctly executed documents wherever they're needed. We might ask for new photos of your offices, and if necessary, an updated employee handbook, telecommuting policy, documents where there's been an update since our last filing. And then with the beneficiary documents, what we're usually looking for is complete set of education credentials. We do ask for a resume. We don't necessarily file with one, and we'll discuss that shortly. Status documents, passport pages for those who have entered the U.S., their I-94 arrival departure record, pay statements, and I-20s. And we ask for a complete set of everything, and we do our best to follow up with the beneficiaries directly throughout the process. but as you can expect with the way that H-1B cap season works, there has to be some sort of compromise in terms of the beneficiary and also the company giving documents that are required to us. So we will, I think the dates are switched, so follow-ups for documents will end on Friday, March 23rd. That's the last day that we're going to send emails to follow up on documents, and the last day we'll accept new documents will be March 26th. So if we don't have everything by then, we're going to file with what we have, and if it's an RFE is issued at that time, we'll submit the additional documentation. We really appreciate you working with us and getting those documents to us as soon as possible. We understand that, you know, everyone is busy. We appreciate you working with us to meet our deadlines as well. Most, if not all of you, should have access to Ignite. You've used Ignite before. If you haven't, we did send out instructions on how to use Ignite in our initiation email. If you have any questions about that, please feel free to send me or Shana an email after this webinar. And so what we're trying to move towards for the corporate document refresh, if there is additional documentation that we've asked for, this is sort of the ideal structure of what we're looking for. So the folder that you're uploading those documents in, we're trying to have tax returns in a folder, quarterly wage reports, if we've asked for press articles, org charts, leases, entity formation documents, or any additional financial documents. So this is sort of the ideal folder. If you could work with us to sort of organize any document refresh this way, we would very much appreciate it. And if you have any questions about that, please don't hesitate to reach out. Okay, so once we have the initiation sheet, we do a case analysis. So there's a plethora of things that we look at. I've highlighted a few of them here. So one of the most important things is deciding whether we're filing this H-1B petition for consular processing or change of status. So what does consular processing mean? That means that upon the approval of an H-1B, the beneficiary will be going to a consulate in their home country and apply for a visa stamp, and then once they've gotten the H-1B visa stamp in their passport, they are then able to enter the U.S. for the first time in H-1B status and begin work. This usually is for people who are currently abroad. These are for people who may not be physically here on the day of filing. You must physically be here on the date of filing to be able to request change of status, and you have to be here in valid status. And I'll talk about that in just a second. So change of status. So this usually falls into for H-1B purposes, we usually see this with F1 students. So you might have candidates who are F1 students on the date that we file, they hold F1 status, and they have no travel plans, and they're able to stay until the petition is approved. Upon the approval, they'll be able to change status automatically while they're here in the U.S. to H-1B status. So there are some considerations. So it's not just F1 students. You might have someone in mind who's an L1 status. You might have someone who's an O1 status. So the status that we will not consider for change of status, though, are people who are here on tourist or business visas. So that means B1 or B2. We will not be doing change of status filings for those cases. But anyone else, so long as they're physically here on the date of filing, we can consider change of status. You'll see when you talk to your beneficiaries that there are considerations for travel. And so while a petition is pending, they shouldn't be traveling. And so upon approval, there are other considerations about travel before the H-1B starts. If it's before October 1st, we can talk about that on a case-by-case basis. The next consideration is extremely important, is determining whether your beneficiary is going to enter the master's cap or the regular cap. So every year, the USCIS allots 20,000 H-1B visas for those who hold at minimum a U.S. master's degree or higher from a accredited, non-profit U.S. university or institution. And so for that, the beneficiary must have had at minimum a U.S. master's, it could be a PhD as well, from a U.S. school, and the date of degree conferral must be before the date of filing. So you might have, what I see a lot is, you might have an F1 student who's graduating in May or June of this year. They might have finished their courses, or they might have one course left for spring semester or spring quarter. And so we can do a case-by-case analysis. If there is a confirmation letter that we can get from the school that they've completed the program as of this date, degree conferral can be, for example, on March 15th, we can qualify them for the U.S. Master's Cap. However, if degree conferral comes after the first date of filing, which is whatever day we end up filing the case, then we cannot put them in the U.S. Master's Cap. If they are selected in the Master's Cap, amazing. If they are not, then they are put in the regular lottery. So the regular cap lottery is for everyone else. So if they have master's or PhDs from abroad, bachelor's degrees from abroad, that's the regular cap. And there's 65,000 visas that are allotted for that part of the lottery. And then the other thing we look at is the time available in the visa category. So usually this doesn't affect most of your candidates, but you might have someone who may have previously held H-1B in the past, or an L-1 in the past, L-1A or L-1B in the last 6 years. And those dates do affect how much time they are able to use with this new CAP petition. So this doesn't happen very often, but we do see them. So if there is a situation like that, we'll reach out to you and give you an analysis. We also will look at status restrictions and violations. So we want to make sure everyone's in status and everyone's been maintaining status if they're for CPT, OPT. And then one of the most important things, at least to me personally, is the beneficiary qualifications analysis. So we're talking about trends. One of the biggest things that we're seeing with RFEs in the last 6 to 8 months is the attack on degrees. So as most of you know, you've heard from me, mechanical engineering for technical roles just hasn't cut it for the last couple years. We don't recommend filing for candidates who have just a bachelor's degree in mechanical engineering for technical roles. However, there is a consideration if they have work experience supported by verification of employment letters for a possible degree equivalency. And I'll get into that in just a second. As a firm policy, we will not file cases if the person does not hold a degree in a related field. So, for example, if you're filing for a computer systems analyst and the person has only a chemical engineering degree and no work experience that might result in a degree equivalency, we're not going to file that case. If the person has a degree in biology and we're filing for a software developer role and there's no equivalency that can be done, we're not going to file that case. And more than ever, they're attacking that. So something you might have experienced with us is in the past, someone might have a mechanical engineering degree, and what we would do is we get an equivalency for just engineering in general, and that used to get through. The USCIS is now attacking general engineering as a qualification for any technical role. It has to be in a specific degree directly related to the field. And then for those who don't have the degree, so let's say you have someone who has a master's in biology, but they have, let's say, 3 to 6 years of work experience in a technical field, so they have served as a QA engineer or as a software engineer. What we would do then is reach out with the resume and the education credentials to our education service and see if the combination would warrant a degree equivalency. So what we see sometimes is some people might have a business administration degree and they might have the work experience. They must have at least 3 years of work experience for this to work. The rule is for every 3 years of work, it could be evaluated as 1 year of education. And so what we see is sometimes they'll have a technical work experience background and a business administration degree. What comes back to us sometimes is an equivalency for computer information systems, which does qualify them for example, a computer systems analyst role. But for that to work, we do require verification of employment letters. So at the stage of the H-1B CAP petition, we do the evaluation to make sure that we could get it equivalency. We'll come back to you and say we'll file without the equivalency at this time. We'll file with what we have, and if the case gets selected, then we would order an opinion that basically confirms a degree equivalency. But this is based on the beneficiary providing us verification of employment letters. So that is the part where we do need that confirmation from the beneficiary. Something that most of you are aware, but we check every year, is a school's accreditation. That changes for certain schools there might be for-profit schools. For example, we do occasionally see Full Sail University. That's not going to fly. So we do check that as well. So someone might have an MBA, but it might not be from an accredited university, so we can't enter them in the U.S. master's cap. If they have a bachelor's degree that we can do an evaluation for a U.S. bachelor's degree, then we can, and it's in a directly related field, we can use that. So how does that affect you? So you might have beneficiaries who have an MBA or a master's in civil engineering, but it's a school that doesn't have accreditation that is recognized by the Department of Education for purposes of the H-1B. So what we would do is then look at the other degrees. They might have degrees from abroad. That might work out. If they don't, then we would have to look at other things and see if this person actually qualifies. This also affects whether or not they can enter the master's cap or the regular cap. So someone might say, hey, I have a master's degree, but it might not meet the requirements for the H-1B. And we talked about date of degree conferral. We'll ask if beneficiaries have dependents, but we will not file H-4 applications for that are only usually filed for those who are doing change of status petitions until the petition has been selected. That saves you money, that saves us time as well. We will, once a petition has been selected, if it's for change of status, then we will reach out and initiate the H-4 component of the filing. So this is more specific to consulting companies. We have seen some trends and changes for consulting placements. So these are specific to consulting companies. Accurate work site location. We want to make sure that when you give us that initiation worksheet, if someone has a suite number, a floor number, we need that. What happens is sometimes we'll get an address, and then when the rights to control documents come in, all of a sudden there's a suite number or a building number, and we didn't include that. In terms of documentation at the time of the CAP filing, we are definitely comfortable filing with just an MSA and a purchase order or work order, and then at the time of an RFE, we'll need to provide the rest of the documents. So I will say this, the USCIS is now reading MSAs, those long, lengthy documents. What we're seeing is if an MSA is more than 3 to 5 years old, they're calling out the date on the MSA. And we know that that's not an industry practice to renew MSAs, but if you have, for example, we've seen a couple cases where MSAs were challenged from 2011. That's technically 7 years ago. So if you're able to re-execute those MSAs with your vendors, we would really appreciate it, and you're supporting your own case. The other thing is they're looking at signatures, so if you see one party signed but the other one hasn't, please go back and make sure you have it completely signed and dated. They're looking at that and calling that out. MSAs might refer to an exhibit, which could be a PO or a work order. Make sure that that's included in there, and if it says job duties are going to be in the PO, they should be in the PO. One of the biggest trends that we're seeing is the dates that they're looking at. So for example, the purchase order might only be for 6 months. We understand that that's an industry practice to only issue purchase orders for 6 months, and I'll get to that in just a second. The middle vendor letter might only have it for 2 years, and then the end client might be for 1 year. We recommend we are changing what our recommendation is for the duration language in letters. I will send out a template to anyone who asks for it, what our updated recommendations are. We want it to basically say in the letters that the placement is contracted through, and then whatever date we're indicating on the I-129. We will not just blanket request 3 years unless we can confirm a duration of 3 years across the documents. We also, for those companies that face vendors that only issue POs for 6 months at a time, we can add language into those middle vendor letters that basically say our policy is to issue purchase orders for 6 months at a time. However, the placement is contracted for, let's say, through January 2021. We have included the most recent purchase order. So that way we're covering why the purchase order date might be 6 months out versus why the middle vendor and end client letters have different dates. And finally, the most important thing, cases used to be able to slip by without an end client letter in the past. That's not happening anymore. you must have an end client letter for cases to be approved. Now, there are certain exceptions. When that happens, we can't guarantee that a case will be approved with alternative evidence, which might be an email from the end client saying that they have a policy of not providing end client letters. We obviously will support you to file whatever we can to support the case, but we are saying to you that without an end client letter, cases will likely be denied. So when we're filing these H-1B CAP petitions, we're okay with just an MSA and PO, but please keep in mind down the line when the RFE comes that these vendor letters and end client letters should support what's indicated in the petition. And finally, I'm really happy to review your documents before you get them SIG signed. I actually recommend that you send them over to us so we review your documents before you get them signed, and we really appreciate that. Okay, so our petitions have been filed. Now what? So USCIS this year is accepting H-1B petitions from April 2nd to April 6th, so the first 5 business days of April. So the first day we can actually put H-1B petitions to the mail for Monday delivery is the Friday before. We usually do it sometimes the Saturday before, so it arrives on Monday. Receipt. So if you remember, for those of you who filed last year, they suspended premium processing on April 3rd, so there was no premium last year. We don't know if they're going to do that this year. They announced that in March. So if anything like that does happen, we'll let you know, but barring any sort of announcement like that, receipt notices for premium processing are expected in May. And then receipt notices for regular processing are expected in June, and through May and June, any case that wasn't selected, they slowly just trickle in when they're returned back to our office, and we let you know as we receive notice on every case and the documents that come in. Okay, so I know that there's a lot of questions that come up about F1 students. We'll release an F1 FAQ after H-1B CAP petitions are filed, but I think these are some main considerations for those who are filing that you might want to pass on to any beneficiaries who have questions. So you might hear about CAP gap. That's the extension of F1 status and any corresponding employment authorization based upon a timely filed H-1B. So what does that mean? You might have someone who has F1 status on the day of filing, so April 2nd, and their F1 status or their OPT or CPT, whatever, might expire July 1st. And the CAP petition might not be approved by then. CAP gap allows the extension of F1 status and corresponding employment authorization until a decision has been made or September 30th, whichever is earlier. So for those whose employment authorization extends, it only extends through October 30th. As of October, so what happens is, September 30th. Thank you, Shayna. So through September 30th. So there are situations, and we faced it last year without premium, where you might not have approvals before September 30th. What happens is, as of October 1st, if the case is still pending because of an RFE or if it's still in process, the beneficiaries not afforded CAP gap relief. However, they are authorized to remain in the U.S. until the H-1B is adjudicated. They will not have work authorization afforded to them after September 30th, though. Employment authorization is only extended until September 30th. They can legally remain in the U.S. while the petition is pending, but they must stop working. There might be questions about the 60-day grace period. I've included it here. So if for any reason a CAP gap, basically an F1 student covered by CAP gap is denied, rejected, or revoked or withdrawn, they do get the 60-day grace period. But if the H-1B is denied due to a status violation or any other sort of thing like misrepresentation or fraud, they don't get the 60-day grace period. Finally, something that's not up here, there are people who might be able to go from post-completion OPT and apply for STEM OPT. They can certainly do that while the H-1B petition is pending. So that is also an option out there for them. If you have any specific questions about F1 students, please reach out. Again, after H-1B CAP is filed, we'll be sending out our FAQs, which you may forward along to your employees. So finally, what if a candidate's CAP petition is not selected in the lottery? And this happens. I don't know what the numbers are for last year in terms of selection. I think it's less than 33% was like a third around there. So we are happy to do a case-by-case analysis. we look at, if you have an F1 student, if it's a new F1 post-completion OPT holder, they actually have and they studied in a STEM field, they actually have 3 years of work authorization they can work off of and get 3 bites at the cap apple. So there's that. We can look at resumes for alien of extraordinary ability. If you have entities abroad, we can talk about maybe considering an L1 for an intercompany transferee that has requirements of its own. If, we do this analysis anyway, but if someone holds Australian passport or Canadian or Mexican passport, we can look at the different the treaty visas. And then finally, it might make sense to start the PERM process in certain situations, which we can also discuss as well. But there are other options we can look at. We can't guarantee anything, but we are very happy to look at the different alternatives. And then finally, visa stamping. Once the approval comes in, we send our approval packet, which has all the information in it. I know that in the past, it was acceptable to just send the beneficiary with just the bottom portion of the approval notice. We don't recommend that anymore. We recommend that you hand over the full original approval notice to the beneficiary so they have that in hand when they go for stamping. You should keep a copy of it for your records. You should be giving a copy of the petition that was filed on their behalf to them. I know that there's sensitive financial documentation that's in those petitions, so you can redact them and provide them in a separate sealed envelope, and then they need to have a valid passport. Once they are approved, this is extremely important and something we've been seeing across the board in the last year, is if you get an approval, if the person gets an approval in, let's say, August, don't wait for the visa appointment. They should be taking close to the start of the approval period. So let me give you an example. So we've seen situations where a person might get a CAP approval and then they'll go for stamping a year later. It used to get through in the past. It's not getting through anymore. And what they're doing is, by filing an H-1B and indicating a start date of October 1st of 2018 or this year, you are telling the government that there is work available starting on October 1st, and there must be work available. So when a person goes for stamping a year after, it puts into question whether there was work available starting October 1st. And so we can talk about plans. I know sometimes, there's considerations of, people who have children and their school and moving and everything like that. But the stamping appointment should happen very soon before around the time of the approval period. We can help with interview prep. That is something that I recommend to everyone. The other part of that is you want to make sure that you instruct your beneficiaries to look at the petition, read their job duties, and not go rogue. They might have a certain understanding of what they're supposed to do, and I think our interview prep sort of guides them. Oh, yeah, so Shana was just saying, we do send the petition to them, to you to send to them. They should read through that petition, and so they understand how to answer those questions. But again, we do recommend that interview prep. We're here to help, so we're happy to do it. Oh, thank you, Shana. And then her final thing is, so once we do file the petitions, our admin team will be sending out copies of the petitions through a downloadable link. Once you get those links, please download it within 30 days of receiving those emails, because they expire within 30 days. You should have them in your records immediately. Okay, so that's about it. You will see in your webinar panel that there's the ability to ask questions through here. So we'll give you a minute. If you have questions that you'd like to submit to us through this portal, please let us know. We'll give it just a minute here. So there is a very good question. So what happens if let's say you filed for an end client placement, or let's start with an end client placement. Let's say that they're placed in Texas, and before the petition is approved, it's a new client, and and the project's ended and hasn't been approved, and you want to move them to a new project. What do you do? Unfortunately, with H-1B CAP, it is solely based upon that petition that was filed. So if you're saying the person is supposed to work for ABC company in Texas, ABC no longer has that work and the project isn't there, and you want to move them to XYZ, that petition, you cannot You can try to amend it, but it will get denied. Unfortunately, that's because it's the initial petition, it's based upon that initial petition. There are certain situations where you, as a company, they might be working in-house, it's a product company, and you move within the same metropolitan statistical area. So let's say you have ABC company in San Jose, and in Santa Clara County, and you just move to Los Gatos, and that's still Santa Clara County. We have been successful in explaining that it's a move within the MSA, and according to the decision in Simeo Solutions, I've talked to many of you about that, an amendment is not required because it's a move within the same MSA. There are certain requirements, though, to do that, which include having to post the existing LCA at the new location for 10 days, and then updating the posting in the public access file. So I have a question here. Isn't it true that you can amend if you can prove the first case even though you amend before October 1st? Definitely. I mean, there is that option. So let's say that, you have a petition, and at the time it moves, and then you file an amendment. If you can prove the amended petition, that initial petition, that there was available work at that time. So let's say you're filed a petition for ABC company in Texas, and then you have to move to the next one. If you can prove that there was available work at through that duration at that time of filing, and the USCIS accepts that, then you can certainly do the amendment and it'll be successful. Part of the problem that we see in terms of filing the initial petition and then doing the amendment is that petitioners have a hard time proving that there was available work through the initial petition. So an option for that to make sure it happens, to sort of support the case, is to premium process those cases. So again, if you have the documentation in a situation like that where you're at Texas, at ABC company, and project ends, but you can prove that you have the available work and then you need to file an amendment, it could help to expedite the process, get the petition approved through premium processing, just to accelerate the process. Then there's less questioning about the availability of work. Oh, I got a question here. Is there any sort of prioritization in terms of how to get a case selected in the CAP? I've gotten this question now, and I've gotten this question this week in email too. Unfortunately, there isn't any way for us to prioritize one candidate over the other. The only, I guess, quote, priority you can do is if the person has a U.S. master's degree, they're put in the master's lottery. If they don't get selected, they're moved to the regular lottery. That's the only real, I wouldn't call it a prioritization of a petition, but that's the benefit of having a U.S. master's degree or higher. But there is no way for us to do anything to support cases to be selected over others. Okay, I'll give everyone a minute. Those are some very good questions. Okay, well, it doesn't look like anyone has any questions. If you do think of something in the meantime, please don't hesitate to reach out to myself. Obviously, if you do, you can reach out to any of us at MPLG, not just me. There's Kalpana, obviously the partner. She's amazing. You can direct your questions to Shayna. She'll make sure we see it. Amir, he's a great resource. We work as a team here, and we're really happy to answer any questions that you might have. Again, you'll see on the side panel under handouts some of those documents that were sent out with the initial initiation email on what you need. Just a reminder that we do need those initiation worksheets for the early bird special by the end of the day next Friday. And finally, thank you. Thank you for joining us on the webinar. If you have any questions, reach out. This is recorded, so we'll be sending this out in the next week, and I look forward to hearing from all of you. Thank you so much for joining us.